Welcome to the NCDWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NCDWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 163 of the NCDWI Guide podcast. On today's episode, we are talking about being default aggressive as a criminal defense lawyer. Being default aggressive. This topic came up today as a result of a part of the conversation that Rob Heroy and I had on last week's episode 162. During our conversation, Rob was talking about the influence that his time being a professional poker player had in being a defense lawyer. Rob was a finalist in the 2010 World Series of Poker, and he talked during last week's episode about how this attitude of being default aggressive, not being willing to settle on anything when it comes to trial, not stipulating to anything ahead of or during trial, making the state prove each and every element of each and every charge without any help from him. And I think that is such a great mentality. And so today we're going to talk about something, and this is something that after he said this, it really connected with me because I have seen the benefits of this so much. So I'm really excited to talk about this topic today. Before I dive into that, I feel like as defense lawyers, we always need good examples. We always need heroes that we can kind of base our life around. And so I've talked in the past about Atticus Finch from To Kill a Mockingbird. We've talked about Thomas More on the podcast several times, but in light of yesterday, which yesterday for those of you that are in the Christian church listening to this, we celebrated the Feast of Pentecost. 50 days after the resurrection, we celebrate the coming of the Holy Spirit. And to me, the Holy Spirit is the best hero that we can have as criminal defense lawyers. Particularly in the Gospel of John. John is also believed to be the author of the book of Revelation. John loves the painting this picture of courtroom. He's constantly talking about witnesses. He's constantly talking about evidence. He's constantly using these legal terms to help kind of paint the picture of who Christ was, both in the gospel as well as in the book of Revelation. And so one of the ways that we kind of see the Holy Spirit painted is as a defense lawyer. So within the Gospel of John and in the book of Revelation, we kind of get this sense of a trial scene where each individual soul at the last judgment is basically a defendant on trial, with all of the kind of evidence of their sin being laid out in front of God the Father, the just judge. And who is the prosecutor in this particular painting? Satan, the accuser, is the prosecutor of each soul, and it is the paraclete. So word that we have for Holy Spirit, the paraclete is painted as this defense lawyer, and parakletos from the Greek is basically a lawyer, and particularly a defense attorney. Paraclete is also often translated as advocate or counselor. And I believe in many languages, even today, paraclete is just another word for lawyer. So in these scenes that John kind of paints out, and how he has Jesus talk about the coming of the Holy Spirit is as this defense attorney, this person that will stand by our side, sitting at our table in the final judgment. And so, in this painting, we have such a great hero to look for on one side of the table. On the prosecution side, you have Satan. On the defense side of things, you have the Holy Spirit, and then obviously the individual soul is sitting there next to the Holy Spirit. So it's good for us, I think, to have heroes to look to, and more than a hero, for those of you that practice the Christian faith. I think that the Holy Spirit provides us a great place for us to pray for help in our particular role, for our particular work that we have, for our particular mission that we have on this earth. When a person is charged with a crime and appears in criminal court, that person deserves, should get a defense lawyer. And in fact, the best defense attorney that the person can get. That's what my belief is that everybody is entitled to get the best defense possible. And so we have this great example of God being personified, the Holy Spirit, but one of the members of the Trinity, the Holy Spirit being personified as this great defense lawyer. And it's a beautiful image. So I think that having, that picture painted out, it really can add a lot of, I would say, value to what we bring into the courtroom, having that image painted in our heads of we get to go to bat for our clients, advocate in front of the judge for our clients. And obviously it's not a perfect analogy, but it is, I think, such a cool thing to have a real hero, God himself, being portrayed in this way. So just wanted to put that out there, one day removed here as I'm recording this from the Feast of Pentecost, when we celebrate the great defense lawyer himself, the Holy Spirit. Just wanted to share kind of that model of what we are supposed to be about, and somebody that we can kind of hopefully imitate in our own practice. So going into this mindset of being default aggressive, Jocko Willink, who the Discipline Equals Freedom sign is behind me as I record this podcast. One of my great heroes. Love listening to Jocko's podcast. Read his books. Jocko really talks about this idea of being default aggressive. He talks about it in business. He talks about it in jiu-jitsu. He talks about it in life. Having this mentality of being default aggressive. Trying to take a stronghold and then capitalize on that stronghold. There is this idea of being default aggressive, and it was something that he was constantly trying to teach to the Navy SEALs that he was working with, that he was leading as an officer, was taking this position of being default aggressive in combat. And at the end of the day, that's what trial is. It's combat. I mean, it's one of the reasons why I think those of us that have had, been involved in competitive sports growing up, or been involved in something like, as Rob was talking about, poker, being a big gamer, whatever it might be, wherever there is competition, when we are no longer able to participate in that competition because we've aged out, or our health wasn't what it used to be, or we don't have time for it, whatever the reason is that we can't do that, we try to put those competitive juices somewhere else. And the courtroom is a perfect place for those competitive juices, a perfect place for exercising on that attitude of being default aggressive. And kind of where, I got to apply Jocko's principle of being default aggressive this past weekend. We brought a family friend into town, and took her and several of our older kids and a couple of their friends and went and played laser tag. My wife and I and all of these teenagers went and played laser tag. And for whatever reason, right before we started this thing, Jocko's mindset of being default aggressive was what came to mind. And so that was my attitude for the entire 45-minute game. There was basically a series of probably like 10 to 12 different games composed of different teams, individual rounds. I mean, it was a great time that we had playing laser tag, but it was wild to see how that principle of being default aggressive did seem to really play to my advantage through most of those games. There's something about being on the attack and not getting pinned down into a specific spot where people know where you are. They know where to attack you. You're not moving around. There's something about being in this kind of mode of default aggressive that really seemed to work. And my scores generally seem to reflect that attitude of default aggressive being one that worked very well. And so I think that is something, again, that it's obviously, laser tag and the courtroom are different, but based on Rob's conversation about poker from last time, I sat down and started thinking about what all the benefits of being default aggressive are as a criminal defense lawyer. And so I've come up with 5. This is a non-exclusive list, obviously, but I really think that this actually has just a ton of truth behind it. And so I'm just going to walk through these benefits of having an attitude of being default aggressive as a criminal defense lawyer. First and foremost, I think everybody would agree with this, is reputation. The reputation. If you are an attorney that takes cases to trial, people know that. Other people will recognize that as you start to take cases to trial day in, day out, week in, week out, month in, month out, year in, year out. People will start to notice that. Now, who notices? What does it matter? Well, everybody in the courtroom will notice that. Judges, the prosecutor, other defense lawyers in the courtroom will notice that. Bailiffs, clerks, people in the courtroom, people sitting in the gallery will notice that you're taking cases to trial. And as you improve as a trial lawyer, there will be, not only a noticing that you're a trial lawyer, but that you're a good trial lawyer. But before you can be a good or a great or an amazing, a spectacular, a super lawyer when it comes to trying cases, you just have to take cases to trial. You just have to go in with an attitude that this is not for plea. We're taking this to trial. That's where we stand, right? And as Rob said, you don't have to go in there angry about it. You don't have to have an attitude of being wild about it, or raising your voice, or yelling, or screaming, or throwing things. You don't have to go in with that type of aggression. It's just this mentality of, we're taking this case to trial. That's the default position, is taking the case to trial. That's what I would kind of compare as being default aggressive in the courtroom. This case is for trial, unless there's some compelling reason not to do that. And there can be a compelling reason, which we'll get into. But again, we're going to trial unless there's some reason to go a different route. And so in my early days, I would consider us now very much a trial law firm. We encourage attorneys at the firm to take cases to trial. We practice taking cases to trial through our regular mock trial days. We bounce cases off of one another that are coming up for trial. We want to push cases to trial. It's a part of our identity as lawyers at this firm, that we take cases to trial. But that was not always the case. In my early days, I would say that I had a aversion to taking cases to trial. Part of it was, I think, a financial justification of, you're going to make, more money by doing high volume, kind of low energy cases than by taking on cases that you're going to kind of need to take to trial. So just this kind of mindset that, over the long haul, volume is everything, kind of default position should be to kind of go the easy way out. So there was some element, I would say, of kind of like a financial mindset, but it really wasn't that, because ultimately if a client wanted to take the case to trial, that's what we would do. But so there was, I think that the financial side of things was more a cover up for my fear. I was afraid to take cases to trial. I didn't want to go in the courtroom and look stupid. I didn't want to go in the courtroom and fight things out. I didn't want to go in the courtroom and be made to look foolish. I just did not want to expose myself. I was afraid of looking like a fool in front of other people. Fear was what led me to be, I would say, of a plea first mindset. And then at some point, we decided we're going to start taking cases to trial, and really kind of that primarily started with me. And so I can remember taking a couple of cases to trial. My first two trials in Superior Court were basically cases that were, kind of back and forth on the SFSTs, not necessarily any kind of like compelling appreciable impairment from the initial officer investigation, and then basically, 0.08, 0.09 alcohol concentrations. And so I tried these cases in district court and appealed based on an Aaron Simmons argument that this, that the state has not proved this case beyond a reasonable doubt, that there's reason to trust the alcohol concentration or that there is appreciable impairment. And the first case that I had these two trials back-to-back weeks. The first trial that I ever had in Superior Court resulted in a hung jury on a 0.09. I believe it's a 0.09 based on Aaron Simmons. I mean, it was effectively, look at what's going on. And, there's all of these kind of like question marks with regard to breath testing that we raised throughout the trial, and the jury was hung. The next case, so a different case the following week, was a 0.08 that we took to trial, Aaron Simmons issue, and the jury returned a verdict of not guilty. The officer had really done a really poor job in terms of HGN, and basically admitted that he had not done it correctly. And there was all kind, the reason for the stop was not that compelling. My client had literally been working as a photographer, shooting downtown Asheville all day long at an event, had a couple of drinks while she was there, but literally had been working all day, was driving away from this work event for herself. And that's when she was stopped. And so basically the jury said, not enough evidence beyond a reasonable doubt to convict, either based on the results of chemical testing or on appreciable impairment. And, before I had tried one of these cases, there was a local lawyer that came up to me, guy I really respect. And I don't think he meant this, honestly, in any kind of like, at the time, I wondered if maybe it was like a disrespectful question, or, some sort of like, what are you doing up here question. But, looking back and knowing him now, I think it was actually really just a genuinely curious. I explained, we're taking this case to trial. And, he was like, well, what's your angle? What's your issue? And I explained, we're attacking the chemical testing, that this is a valid basis based on all of the other evidence that was collected, that this is enough to get to a point of beyond reasonable doubt, and using Aaron Simmons to argue this to the jury. And I think, I could get a sense from him of like, well, good luck. That doesn't sound like a really good, good case to take to trial. And I think that most people would have thought that way. And, I think there's different jurisdictions where maybe this is, a better issue than others. But I think here locally, there was a sense that, what are we doing here? Both from the prosecution and from kind of the defense end. Why are you trying this case? And I think that as Wayne Gretzky, is so famously said, you miss 100% of the shots that you don't take. And if I had not had that mentality as a young lawyer of kind of not knowing any better to some extent, I mean, it was almost like, didn't understand, like, this is not the way the game is played, so to speak. So almost due to naivete, I went ahead and took these cases to trial with, good results at the beginning end of that. And so what I think, that shows, that really changed, to me, the way that our firm operated. And I can remember a couple of months after that, one of the other attorneys that was working at the office came in, sat down with me and just said, "Hey, Jake, I just want to tell you that, I'm really grateful that you've taken these cases to trial, because we are now being perceived differently than we were a couple of months ago. We're being taken more seriously because we're a firm that takes cases to trial." And he was really primarily speaking about how we were being perceived not by the DA's office or our judges, but by the criminal defense community. And it was very interesting to kind of hear the way he laid this out, because I wasn't really seeing it in this way. I just thought it was going to be something that was going to be, good for us in terms of advocating for clients and kind of building our business. So, it wasn't really necessarily a reputation thing at the time, but I do think that has a humongous impact on your reputation. And so, when it comes to DAs and judges, DAs know which attorneys are going to take a case to trial and who is not, who's simply not going to take a case to trial. Now, in the civil world, right, let's say somebody gets into a car accident, they call a lawyer gets involved, personal injury, a lawyer gets involved on the case, and they're going up against the insurance company. Does the insurance company care whether the personal injury lawyer takes cases to trial or not? Yes, they do, very much so. In fact, their artificial intelligence, the Colossus software that is designed to lower settlement amounts, that settlement offers that are made, looks at all number of different factors, computerized and constantly pulling new data in based on settlements that are occurring. But it identifies as part of its artificial intelligence which lawyers are taking cases to trial and which lawyers are not. And those taking cases to trial are generally going to get a better settlement offer than the ones that don't. Why? Because it's expensive to take cases to trial from the insurance company side of things. So they know which lawyers are coming in and, just looking for a quick buck. And they know which lawyers are coming in and ready to go to bat in the courtroom if they're not getting a legitimate offer. And I think that this plays out so much in the criminal courtroom, because while there's no artificial intelligence program that's evaluating criminal defense lawyers yet, I will say yet, because that's not something that is out of the realm of possibility. While there's no artificial intelligence that exists at this point in terms of plea offers that are being made, DAs are that artificial intelligence. They know who's going to take a case to trial. They know who's going to make a deal. They know what the deal is going to look like. So it's going to make a difference. If you have a reputation as a trial lawyer, and I've seen this because we have offices throughout the state, it's something that is a little bit easier to kind of hear these stories from our different attorneys practicing in different locations. When you walk into the courtroom and you're known as somebody that takes a case to trial, it's just so much easier to get a reasonable offer, to obtain a dismissal, because the DA knows that this is going to be something that ends up in trial unless they kind of make the movement to otherwise resolve the case. So it really does, to me, make a massive difference in terms of negotiations that go on with the DAs. Judges notice attorneys that go to trial. Again, other people in the courtroom do as well, but judges know if you are a lawyer that is taking cases to trial or not. I mean, they see the same faces day in, day out, month after month, same people are in the courtroom. So they know which lawyers are taking cases to trial, which lawyers are advocating well for clients in the courtroom. You're building that reputation. And again, before you can be perceived by the DA or by the judge as, super lawyer of DWI or super lawyer of criminal defense, you've got to just be an average lawyer trying cases, maybe even a below average lawyer trying cases, because if it's your first couple of trials, you're just going to make a lot of mistakes. That's just the end of the game right there. I mean, it's just, you got to get past the fact that I'm going to mess up. I'm going to miss things. I'm not going to lay this out well. I'm going to stutter. I'm going to use the wrong terminology, whatever it might be. It's going to look ugly the first probably 15, 20 times that you go into the courtroom, and you're going to continue to make mistakes every single time that you try a case. There's never going to be a perfect trial start to finish. I don't think that exists. They could always have gone better. There could have always been a different way of presenting evidence, putting on different evidence, and there's just no way to kind of pitch the perfect game, so to speak, in the courtroom. But you do get better. But before you get better, you just got to throw things up there and get practice reps in trying cases. So again, with the DAs and judges, and then again with the defense bar that you practice in, you will earn a reputation as a guru in criminal defense. If you try a lot of cases, you will be recognized as somebody that's going to force the issue, as somebody that's going to push the state, and that's going to bring value. I mean, whether that's through a referral from somebody that's, maybe only handles speeding tickets and doesn't want to take on this particular DWI potential client that seems to say, hey, I really want to take this thing to trial. You're going to get referrals based on that, but you're also just building a brand as an expert in the industry by pushing cases to trial. So reputation, to me, is the number one benefit from being default aggressive in the courtroom. Hey, podcast listeners, I want to briefly interrupt today's episode to invite you to join me at the inaugural Freedom Fighter Summit in Asheville this October. This in-person only event is designed for growth-minded lawyers determined to take their criminal defense practice to the next level. Due to the size of the summit's venue, there are a limited number of seats available. Don't miss out on the incredible lineup of speakers and spectacular networking opportunity that this summit provides. For more details, visit www.miniclaw.com/summit. Enter the promo code NCDWI-GUY, all lowercase, all one word, at checkout for $150 off your summit ticket. Look forward to seeing you there. Now back to the show. Number two, this is very practical, and I'm not going to be very long-winded on this one, at least so I believe. Number two, it's easier to go from trial to plea than from plea to trial. I'm going to say that again. It's easier to go from trial to plea than from plea to trial. If you are going into a case with a mindset of, we're going to take this case to trial, it's always going to be easier to kind of move from that position to a plea agreement than vice versa. I have seen lawyers that kind of take a plea first approach, and the amount of energy that gets expended sometimes trying to convince a client that maybe wants to take the case to trial versus plea is monumental, because again, it's so much work if your mindset is, okay, we're going to go in and plea this thing out, to then going to, oh my gosh, we're going to have, a multi-day trial on this particular issue. Whereas if you go into it with a trial first approach, and that's how you're presenting everything to your client, we're going to take this case to trial. This is how the evidence is going to be presented at trial. This is what it's going to look like at trial. You're using the same terminology with the DA's office. When this case goes to trial, here are the strengths of my case. Here are the weaknesses of my case. But talking about it as trial is coming down the road. That's where the kind of final destination is expected to be. And I saw this recently on one of my own cases where, my client was facing a pretty significant amount of time on a felony case. And from the get-go, I thought that there was some very attackable issues with regard to the case. We basically from day one, this case is going to trial. That's what we're pushing for. It's going to trial. And so, every conversation I was having with the prosecutor, every conversation that I was having with my client was, again, here's what this looks like if we take it to trial. Here's the current, agreement or offer from the state, laying that out. But again, the default position was trial. And just before trial was scheduled to occur, we finally got an offer, a misdemeanor offer that was really going to basically, it was the felony that my client was concerned with more than even the time, because of the work that he was involved in. And based on that, we went ahead and entered a plea to the case. But I don't think we would have got that offer. We didn't get that offer. We had gotten multiple, I think, offers that were not going to allow for that type of a resolution. We wouldn't have got that offer if we had kind of been in a plea first mindset. And also, when communicating it to my client, I still wasn't saying, hey, you've got to accept this. This is such a sweet deal from the DA's office. I basically said, I still feel like we have a good chance if we take the case to trial, but I understand that, employment on your end is extremely, important, that this is something that, would allow you to be able to continue in the profession that you are in, so, I understand if this makes the most sense, talk to your family about it. I was under no feeling of pressure that despite getting this misdemeanor offer, we shouldn't take the case to trial. So I think, it just allows for, an easier move. It's just so much easier to go from trial to plea than from plea to trial. Anytime that I have had a assault charge, I mean, these to me are like some of my least favorite charges to handle, mostly because whenever there is a victim involved that intimately, I feel like there's so much sway that their position has with the state, and rightfully so. But it's very difficult to predict how assault cases are going to be resolved in the courtroom. And so I don't like that, because I don't like having consultations with my client where we don't know how things are going to end up, where I really can't give them a forecast of how the state is going to proceed. And so it's one of those situations where I really feel like, having a mindset of, okay, on assault cases, it just became this, trial first. That's where we're going. The expectation is trial. If anything happens where we're able to work this out without that, great. But we're just, I'm going in with the mindset of trial. For whatever reason, it's just so much easier when I walk in the courtroom with that mindset versus walking in being like, oh, my client thinks that the victim is going to, or prosecuting witness is going to make a recommendation that this is dismissed. So that's probably what's going to happen. Or, my client doesn't have a prior record, so they're going to get, some sort of first offender offer. I feel like anytime that I've gone in with that mindset, things have gone wildly off the rails. So going in with this trial first mindset of, look, the case is for trial. If there's some other resolution, again, that presents itself and makes sense, great. It's just so much easier to move from trial to plea than from plea to trial. So just practical benefit. So that's number 2. Number 3 is that being default aggressive builds trust. It builds trust. It builds trust with your client. The first time that you have the opportunity to build trust, to create that first impression with your client, is during the consultation. And I'm telling you right now that any person that talks to you on the phone, any potential client that calls on, let's say, a DWI on the phone, they know whether you want to take a case to trial or whether that's not going to happen. They can tell. So that they are able to kind of sniff out, is this somebody that is going to go to bat for me in the courtroom, or are they not? And again, I don't think that means that every single person that calls with a DWI decides, well, I'm only going to go with the lawyer that wants to take cases to trial. There's a whole other number of factors and that build trust and reasons for hiring a lawyer. So that's not going to be enough to win every client. But the client knows whether you are a lawyer based on your communication and how you're describing handling the case, whether you are going to potentially take a case to trial, whether you think there's any chance of winning a case in the courtroom. They're getting that out of that initial consultation. So if you want to, again, have this default aggressive trial first attitude, that is going to reap rewards, in my opinion, in building trust with the client that, hey, I'm going to go to battle for you. Again, I'm not saying I can win every case, but I will go to battle for you in whatever form that looks like, whether that's trial, whether that is, fighting like hell for the best plea offer, whether that is in sentencing. I'm going to go to battle for you. They can feel that. And that continues throughout the representation. When you call them about the evidence and explain, here are again the strengths and weaknesses of our case, as you're going into court each and every time, clients can tell whether or not you are getting after the state. Are you somebody that is pushing the state for discovery, pushing the state for evidence, asking questions of the officer, demanding that certain notices be sent, whatever it might, what it might take. Throughout the representation, clients can tell when somebody is going to war for them. And I've seen this so often in trial, where a defendant loses at trial. They're found guilty at trial, and I've seen this both with my own clients, but it's almost even more fun to third person watch it when it happens to somebody else in the courtroom. I've seen clients that have walked out of the courtroom with their lawyer and been like, you know what, I can't believe that I wasn't. I wasn't, given a verdict of not guilty, but you just crushed it. Like, I can't believe, you went to war for me. I appreciate so much what you did in there. It's so wild to see that after a loss, when somebody believes that they should have been acquitted, but really doesn't matter in terms of their feeling of the legal service, because their lawyer went to war for them. I've also seen that in sentencing. I've seen clients that, have gotten that attorney that has just gone to war for them in sentencing, versus just presenting these, few mitigating factors. And then basically it's this just transactional, sentencing hearing. You can tell when a attorney is passionately representing their client in the courtroom at whatever stage of representation. If you feel like your lawyer is going to battle, is going to war for you, there is a built-in trust that comes with that. There's a built-in confidence in that lawyer's services, because they have your back. And that is something that I really think is huge in building your reputation with each client, and building trust with each client, but also then having your clients go out and be your best spokespeople, and generate referrals, because they can tell firsthand how it felt to have somebody go to war for them. So number 3 benefit from being default aggressive is that you build trust with your clients. Number 4 is recruiting. So this only applies if you are looking to hire an associate attorney, bring on a partner, go into business with another lawyer, whatever it might be. But for recruiting purposes, being a trial firm is so advantageous because the best young criminal defense lawyers want to fight. That's why they want to become criminal defense lawyers. The best, the most passionate young criminal defense lawyers want to go to battle for clients in the courtroom. They don't imagine, nobody is sitting in their, kind of criminal defense daydream fantasy, thinking about the amount of amazing plea deals they're going to get for their client. Like, that's not happening. They're imagining taking an important, high-profile case to trial and sticking it to the prosecution. So if you want to attract the best and brightest young lawyers, then having a culture of default aggressive, having a culture that we are a trial law firm is absolutely huge in recruiting. Again, there's so many different things that go into where somebody might want to end up, might want to land as a young lawyer, as somebody fresh out of law school. Obviously, salary, location, benefits, spouse. All of these different things are playing into what job opportunity is right. But do not discount the value of being a trial first law firm, of being a firm that takes cases to trial. That to me is a huge recruiting piece. If you have built that culture, if you have built that brand as being default aggressive, you will be able to get young lawyers that are passionate about criminal defense, that are go-getters, to come in and join your firm. So number 4 benefit of being default aggressive is recruiting. And then finally, last, number 5 is mentality. So, we talked about like kind of all of these, like I would say practical benefits, but this one is like a mindset benefit to being default aggressive. And that's loving versus fearing the fight. Being excited about the battle, being excited about the competition. And while I was at one point, again, very nervous about taking cases to trial, it became just this passion. There really is nothing more exciting, mentally challenging, fun, as taking a case to a jury. I mean, it is just, to me, like the height of being a lawyer is being in front of a jury. And that, I mean, it's just something that, again, not maybe there are some people that are born with that. I certainly was not. It was something that changed as I started to take cases to trial, that I really started to enjoy that fight, that gamesmanship that is going on during a trial, whether it's in district court or superior court. A couple of examples that kind of came to mind in terms of this mentality, where I just a few days ago watched the new Amazon Prime movie entitled Air, which is basically about the shoe deal that Michael Jordan got out of college with Nike. And a great movie. Matt Damon, Ben Affleck. I mean, really it was a good watch. So if you're looking for a fun way to spend a couple of hours, I haven't seen a ton of great movies recently, and that one was definitely a fun watch. But they talk in that movie or show at various points in the movie some of Nike's kind of 10 founding principles. And 2 of them in particular really stick out to me as being default aggressive, and certainly like are showcased as being part of the reason that Nike kind of went aggressive in this kind of very unique shoe deal that it offered to Michael Jordan. One of those principles is this: we're on offense, period, all the time, period. We're on offense, period, all the time, period. You hear that kind of adage that the best defense is a great offense, right? Like you keep the other team off the field while you're on offense, they can't score points. Like if you keep their offense off the field because you've got such a great offense, that's the best defense that you can have. For Nike, that was part of the founding principles. And again, like, being showcased in this movie as part of the reason that they went aggressive after Michael. We're on offense, period, all the time, period. The second principle of Nike principle during their or founding Nike principle is, quote, "This is as much about battle as about business, period." This is as much about battle as about business. You just see that warrior mindset, right? Like again, obviously these principles might just be in some companies just words, right, that are offered, like here's our core values, we don't live them out. But with Nike, you get the sense that this kind of idea that we're in combat. We're not in just this kind of like we're not in an office space. We're in a war zone. That's what's happening. Like when we come into the office every day, when we come through those corporate doors, we're marching into battle. And there's something about that kind of like battle imagery that is so helpful in business. It's so helpful, obviously, in like sports and competition. It's so helpful in the courtroom. When you walk into the courtroom, when you walk into the courthouse, think of entering a battle zone, right? Because you're going to war for your client. You're going to be fighting like mad for your client's rights. And in some situations, I mean, I've never had a case like this personally, but in some situations, their life is on the line. Like, I mean, truly, or even from, just kind of a length of time that they're looking at, or the impact that this is going to have on their job, on their reputation, on their relationship with their family. Like, this is going to leave like a long lasting mark on their lives. And so when you think about it from that perspective of, I need to go to war because my client is potentially going to be, irrevocably damaged by this outcome. That's such a different mindset than walking in and just thinking about it as business. This is battle, not business, as Nike presents it. So I love that kind of warrior mentality. So those two principles from Nike. And then finally, another example when it comes to mentality is the example that we get from basically David and Bathsheba from the Bible. We all know this story about David falling in love with this, a beautiful woman who is married to somebody else, and basically this terrible situation where David basically sends Bathsheba's husband out into battle and basically like kind of effectively murders him, like basically lets him puts him at the front lines, and then basically calls the army back so that he can, basically is almost guaranteed death. I mean, like literally, like there's no other outcome where that doesn't happen. So we all know this, but where does David's sin start in this story? And this is, to me, very much tied to the default aggressive mindset. So here's how that story starts out. At the turn of the year, the time when kings go to war, David sent out Joab along with his officers and all Israel. So here's how it starts. At the turn of the year, the time when kings go to war. What should David have been doing at this time? He should have been going to war. Instead, he's sending out all of his officers, right? He's not doing what a king does, which is being default aggressive. He's not going to war. Instead, what is he doing? Well, this is a couple of verses down from that. One evening, David rose from his bed and strolled about on the roof of the king's house. From the roof, he saw a woman bathing. She was very beautiful. These are the lines. So instead of being at war, instead of doing what a king should have been doing at that time, David is taking a nap and then lollygagging around on the roof of his house. What is he doing? He's being comfortable. He's being complacent. And so the beginning of David's sin, the beginning of his downfall isn't this murderous plan to kill Bathsheba's husband Uriah and destroy him while he's in battle, this kind of murderous, adulterous plan. His sin starts from basically having the mindset of being soft when he should have been going to war. He should have been default aggressive, and instead he was being complacent. He was being comfortable. And so I think that this mentality of having this aggressive position, will it help you in the courtroom? Yes. Will it build your reputation in the legal community? Yes. Will it build trust with clients? Yes, it will. But ultimately, it's going to make you a better human being. Having this attitude of being default aggressive, of being relentless, of being in a attack, offensive position repeatedly, it's going to make you a better human being. So number 5 benefit of being default aggressive is mentality, having a go to war mentality. Hope this has been helpful. Look forward to speaking with you again next time. If you found the information in this podcast to be valuable, I simply ask that you pay it forward and share this podcast with another member of the legal community. Also, if you would leave us a rating or a review on whatever platform you are listening on, I would greatly appreciate it.